Hello and welcome to the Kevin Mannix Report. I'm Kevin Mannix, your host for this program, which is designed to give all of us a little more insight into what goes on in and about state government in the state of Oregon. Our report today will be a little bit different in the sense that we'll be focusing on certain measures that will be on the ballot this November 1999, through a mail ballot process. But we will have as a special guest a gentleman who knows all about those measures and someone who has been on this show before. I'm referring to our guest today, Marion County District Attorney Dale Penn. Welcome to the show.
Thank you, Kevin. It's a pleasure to be here.
One of the things we always do is we try to get a little background information about the guest, and even with this special format show, we'll do that because it helps people to have a little more understanding about who's doing things in government. And many of the viewers may have seen you before, but you'll probably be a fresh face to others. So who is this guy, Dale Penn? Where do you hail from and what do you do?
Well, I went to University of Oregon Law School and graduated in 1976. Was a deputy prosecutor here in Marion County from 76 to 79, and was in private practice for 1 year, and then came back to Marion County DA's office 1980. Have been in the office ever since. In 1984 I was elected district attorney and have been running the office for about the last 16 years.
Now you also have a family. You want to tell us a little bit about them?
Sure. I have a daughter who works at General Headquarters at Oregon State Police, one son who's a freshman at Emory University, and another son who's a senior at Sprague High School. And my wife works for a local CPA firm here in Salem.
You're also the head of, or you've been the head of the Oregon District Attorneys Association, and you've appeared before the legislature in that capacity. I don't know if you were just re-elected to that or if that's pending. Are you still president of the Oregon District Attorneys?
No, I'm not president. I have been president. We have a rotating term for offices, but I've been legislative chairperson for about the last 9 sessions. So it's a long time working in legislative issues, and probably will continue to do so being here in Salem. I've also been in charge of the Oregon Criminal Justice Commission, the chairperson of that, which has some involvement in classifying crimes that the legislature passes under sentencing guidelines, and really trying to deal with some issues that affect the entire criminal justice system.
Now we're going to focus today on certain ballot measures on the ballot, and for the moment I'm going to explain to our audience about a couple of measures that we're not going to deal with. And folks, you'll find a mail ballot coming out in the middle of October. You're going to see measures 68 through 76 on that ballot. That's right, there'll be 9 measures. They're all referrals from the Oregon legislature. Measure 68 has some fine-tuning in it as to the prison work program, which was enacted as part of Measure 17 in 1994. It's not controversial. Nobody's known to be opposed to it. You can read about that one in the voters pamphlet, so we won't be talking about that one today. There seems to be general support for that. Measure 76 at the other end of the numbers is a measure which relates to the legislature's repeal of the weight mile tax. This says that the legislature will have to make sure there's an oversight process. It's a constitutional amendment that provides that there will be oversight to see if the new diesel tax holds trucks accountable in terms of their share of damage to the roads. It's a fairly technical subject. There'll be a lot of debate about that, but I'll direct you to your voters pamphlet for that one also. Now that leaves us the ones inside those numbers, 69 through 75. Those are 7 ballot measures which are constitutional amendments referred by the Oregon legislature, and they came out of the legislature as a result of Measure 40, passed by the voters way back when, not so long ago actually, 1996, with 59% of the vote. When Measure 40 passed, there was a court challenge by some criminal defense lawyers. The Oregon Supreme Court finally decided that actually Measure 40 affected several parts of the Oregon Constitution and therefore should have been presented as separate measures, and so they invalidated it even though it had passed by a large margin. The legislature this last session has taken a look at that court decision and has referred 7 ballot measures to the voters. And that's what brings us to Dale Penn. Dale, you were heavily involved in the process last session, working with the Senate committee as well as my committee in the House on behalf of the district attorneys. What I'd like to do today is touch on each measure and ask you to give us some idea as to why the District Attorneys Association asked the legislature to refer these and why you think it's important. The first measure we have up is Measure 69, and this is sort of the generic victims' rights measure that talks about the victim's right to be present in court. It also talks about the right of the victim to at least participate in some discussion as to what is happening with plea bargaining as to serious cases. Can you give us some idea why Measure 69 is on the ballot and why it's important?
Well, I think generally, I need to say about all of these measures came forward from crime victims and organizations who represent crime victims. And I think every one of these measures has a number of crime victims who have said, you know, in my case, we ran into big problems, and this was the reason. And so for us to make a change, we want so that in future cases, other victims don't run into the same problem, there should be a change. And so that's what led to ballot measure 40, and I think ultimately to each of these sections that have been placed on the ballot by the legislature. And I've got to say, in that 24 years or so that I've been a prosecutor handling criminal cases, I've talked to thousands of victims over those years. And I have heard victims complain about different parts that are represented in these measures, that the system doesn't seem to be fair. All of the rights are given to a defendant. And I think the measure here, the intent is not to remove any rights from any criminal defendant, but to give some rights to a victim, to elevate the position of a victim in the criminal justice system so that they have rights as well, so that our system is more fair and does seek justice for all, not just to protect the rights of the criminal defendant. So this first measure, 69, has a number of provisions that primarily give notice to victims, that require in major felony crimes that they be consulted by the prosecutor, that they have a constitutional right to speak at sentencing. And some of these things, they have some statutory rights to do the same things. But I think last spring there was a case decided by the Oregon Supreme Court that illustrates why these rights need to be in the Constitution. We know the defendant's rights are constitutionally based. And unless a victim's right is also constitutionally based, any constitutional right, if it conflicts or in any way competes with a statutory right, that statutory right is going to fail. And so that's why a criminal defendant's rights being in the Constitution, a victim's rights need to be elevated to the Constitution also.
So in the hierarchy of values, as you're putting it, the constitutional values and powers and rights are up here. The statutes are below it. They can be passed by the legislature or whatever, but constitutional provisions have to be enacted by a vote of the people, can only be changed by the people, and those are the bedrock provisions in the Oregon Constitution. They can be adjusted, but only by a vote of the people. Your point being victims' rights being statutory, defendants' rights being constitutional. If there's any time a conflict, the defendant's rights will control the victim's rights.
That's correct, and that's what's already occurred, and that's why they need to be on the same level. Now, critics would say, well, gee, will this prevent a defendant from receiving a fair trial? And I think what needs to be recognized is that each of these constitutional measures is drafted in such a way that if a defendant's right to a fair trial is ever infringed by one of these victims' rights, that the one that's going to win out in that constitutional issue is a defendant's right to a fair trial.
Well, in fact, there's a federal constitutional right to due process which would trump any interpretation of the Oregon Constitution that might say, well, this victim's right is going to control the defendant's rights. There is no victim's rights provision in the U.S. Constitution, for better or for worse. So there is the right to a fair trial under the due process provisions of the federal Constitution. So you're saying, essentially, the protections are there for the defendant. let's do the best we can for the victim.
That's correct. That's exactly correct. And the critics that would take each of these measures and say this is pulling rights away from the defendant, that is just not accurate. That's not true based upon that analysis you've just given, that the defendant's federal constitutional rights are always there and override all of this.
Well, let's take a look at ballot measure 70, which goes beyond victim access to the courtroom and victim access to the process, to talk about another provision in the system, and this has to do with the right to a jury trial. And perhaps you could explain to us what this provision is about.
Well, we all know that a defendant has a right to a jury trial. That is something that is in place both in the federal and in the state constitutions. Right now, the court has told us that a victim, or through the state, the prosecutor, you cannot request a jury trial themselves. And so this measure would say that a victim, as presented by the district attorney, can also request a jury trial. The thing about this is that in the federal system right now, a defendant has a right to a jury trial, but he cannot change and say that I want a judge, a particular judge, to hear my case without getting the permission of the prosecutor. In 1930, around 1930, this provision of a defendant's right to a jury trial was adopted in Oregon by the voters. It was a constitutional amendment added to the Oregon Constitution. And when our Oregon Supreme Court looked at that measure, it was very clear from the voters' pamphlet that what the voters read was that a defendant would have a right to a jury trial. He could waive that right with the permission of the judge. And in the voters' pamphlet, they went forward and said, of course, the judge would never allow that waiver without getting approval of the prosecutor. However, the Supreme Court, when they looked at the measure itself, they said, hey, there isn't any provision that says the state or the victim has to give permission for the defendant to waive the jury trial. So that's why they've ruled that only the defendant has the choice, right to jury trial or to waive it and pick a judge.
So people would say, so what's the problem? The defendant has a right to a jury trial. If he decides he doesn't want a jury trial, why should the state or the victim or the prosecutor object?
Well, I think what victims have complained about throughout the state is that in some situations, defendants waive jury trials and try to get their case to a particular judge who may not be very open to a child abuse kind of case or burglary kinds of cases or that type of thing. I mean, every person, every judge has their own biases. And that has been misused by criminal defendants to give them an opportunity to escape justice. And that's the way crime victims have seen this measure.
So they're just saying we victims want the same shot at demanding a jury trial as the defendant has.
That's correct.
And what would the objection be from the defendant's perspective, other than the fact that he right now gets to play games? He's prevented from playing games, but he still gets justice. He gets a jury trial, he's guaranteed that, and he can get away from a jury trial if both sides agree. Is there a problem here?
Well, I don't see that there is any difficulty with that provision. As I said, that's the exact same situation as it exists in the federal system right now. The complaint I've heard is that people tend to say, well, the defendant has a constitutional right to pick a judge. But that isn't correct. The defendant has a constitutional right to a jury trial, and that is not prohibited whatsoever with this victim's measure.
What we're doing is making sure he doesn't have a constitutional right to judge shop.
That's correct. That's exactly correct.
Well, the next one up is ballot measure 71, and this is another one that came out of measure 40, a case. This has to do with pretrial release. Yes. And we've heard contentions that this is going to lead to all kinds of people being held up pre-trial who ought not to be held pre-trial. Can you give us an idea of what this measure is about?
Yes. This situation is one that I have heard from almost every crime victim in every case we've ever done, is the concern that this person who has harmed them, the defendant, is let out of jail and is out in the community, and their fear that they will be harmed again. So every victim is concerned about this. This measure simply says that historically in the past, the court could only consider whether or not someone was going to appear for their trial. And if they have a history of not appearing for court, well, the court could raise bail, keep them in jail until their trial occurs. However, the concern is, what about the dangerousness of this person? Can the court consider that? And in the past, the courts have not been able to consider that. And that's what's made crime victims upset. Because the physical safety of the victim, as well as the physical safety of the community, are very, very important and should be a consideration. So this ballot measure simply says that the court can take into account the dangerousness of the person on major violent felonies on the release status.
As I understand it, it does require that the judge has to find that there's a probability that the person will be convicted, that there's probable cause based on the evidence already available. Go ahead.
Yes, and I think that's the thing that some people, the opponents, don't really recognize. There has to be a court hearing on this. A judge just can't say, I'm going to hold you without bail. There has to be a hearing, and I would, or the prosecution would have to submit evidence. We would have to convince the judge by clear and convincing evidence that, first of all, that this person is the one who did the crime, that there's evidence of their guilt. Number two, we'd have to prove that there is a situation based upon their background or threats. There's evidence that this person is a danger to the victim or to the community as a whole. And the judge has to make those findings to be able to hold someone pre-trial.
And will that prevent the kind of situation we've seen, such as the unfortunate incident a few years ago in Marion County, where a woman who was a victim of domestic violence, the husband was charged and then released, and she was in continuous fear, and then ultimately, while in a car in a parking lot, he walked up to the car and shot her through the window, if I remember.
Yes, it certainly gives a tool there for the court to hold someone who has made threats or is dangerous, and right now the courts really don't have that authority, and that's why I think it's very important. And as I said, as I have talked to victims, this more than anything is always the first concern they have about our present system.
All right. I'm going to pause for a moment and mention to our audience that you are with us on the Kevin Mannix Report. This program is designed to give all of us a little more insight into what's going on in public affairs. Today we have a special program on victims' rights, and our guest today is Dale Penn, who is the Chief Prosecutor, better known as the District Attorney for Marion County. If you ever have any questions or concerns, feel free to write to me at the Kevin Mannix Report, 2003 State Street, Salem, Oregon 97301. We're always happy to hear from you. You can also call the office at 503-364-1913. That's 503-364-1913. And again, we're happy to hear from you. Returning to Mr. Penn, we've gone through measures 69, 70, 71. Next up is ballot measure 72. And again, this will be a mail-in ballot. Ballots go out in the middle of October. They're due back by November 2, and it's a statewide election. Taking a look at my information sheet, this reminds me that this one has to do with the 11-to-1 jury verdict provisions for a murder case, as opposed to the 10-2 that's allowed for all other criminal cases, and the 12-0 that's required right now for the verdict in an aggravated murder case. Can you explain the rationale behind 72 and what it's about?
Yes. Presently, as you said, on felony cases, a person can be convicted by a vote of 10 of the 12 jurors. And a person can be acquitted, found not guilty, by a vote of 10 of the 12 jurors. But also, presently, for murder and for aggravated murder, it requires a unanimous verdict to convict, but still a 10-to-2 verdict to acquit or to find someone not guilty. This measure simply says that for murder, an 11-to-1 verdict would be sufficient to convict. Now, it does nothing to change the aggravated murder requirement of a 12-0 verdict, a unanimous verdict. And aggravated murder are the cases where death penalty might be imposed or life with no parole could be imposed.
So we leave along the death penalty situation and say
yes,
that has to be unanimous for conviction and for the death penalty to be imposed.
Yes, that's correct.
And then for all other crimes, generally there's a 10-2 provision where you can be convicted or acquitted by a 10-2 vote.
Yes.
But right now murder is included in the aggravated murder death penalty group. This measure drops murder down to somewhere in between and says an 11-to-1 vote to convict. It can still be acquittal, that is, you're set free on a 10-2 vote, but it takes 11-to-1 to convict. What's the rationale for that change? What's the merit to this?
Well, again, there's a number of victims throughout the state that would point to their cases where one juror has not been truthful about their background, or one juror has basically held the rest of the jury hostage, where 11 of the jurors would say that there is absolutely no doubt whatsoever that this person committed the murder. But one juror can have veto authority over the whole jury panel. And several victims have situations where unjust results have come forward because of that. And they believe that there should be this interim step for murder. Again, not death penalty, not life without parole.
And we should remember, when we first initiated this, when Oregon first established the 10-2 vote, murder was generally a crime that could lead to the death penalty at the time. Then it was split into aggravated murder versus murder, and murder still has tagged along with the aggravated murder jury vote. This will pull murder sort of in between the aggravated murder death penalty case and all other criminal cases.
Yeah. And I might say, I mean, people always ask me, well, what's the difference between murder and aggravated murder? Murder is the intentional killing of a human being. And aggravated murder is the intentional killing of a human being plus an aggravating circumstance, such as killing more than one victim, killing someone for money, use of bombs in killing people, those types of things, use of torture. So it requires an aggravating circumstance besides the killing.
So here we'll make one more distinction between murder and aggravated murder.
Yes.
Well, we'll move on here to ballot measure 73, which can be a little complicated for some folks because even lawyers have trouble talking about it. It has to do with your right not to be forced to testify against yourself about a crime.
Yes.
In the federal system, as I understand it, they use what is called use immunity, which means they can't use your testimony against you if you're forced to testify, but they can use other evidence. But in the state of Oregon, we are required to allow transactional immunity under current interpretations of the Constitution. Could you explain what this measure does and why we're making some changes?
It is complicated, but let me say that the Oregon rule requires a prosecutor, the state, to give total immunity. That's what transactional immunity means, total immunity. This measure and what is available in the federal system says that you simply cannot use someone's testimony against them. Now, the way this comes up is this does not violate anyone's Fifth Amendment self-incrimination protections. It comes up in a situation like in gang violence, or we have multiple people involved in the crime. And one of those individuals does give a statement to the police and admits what they did. The other four people say, buzz off, we're not talking. So now you have a situation that can be very difficult to prove, like a drive-by shooting where there's a murder that occurs. Where there's one person that can be a witness there, but under Oregon's rules, if you're going to call them as a witness and ask them those questions, tell us what happened, they have to be given total immunity. And victims, again, don't think that's fair, that that person, even though they have cooperated a little bit, and maybe they should get some benefit, they shouldn't get a free walk. With use immunity, what you can do under this measure is You can tell that person, we have your statement to the police, and we have other independent evidence that we can use against you. You don't get immunity for that. But if you go in and testify, anything you say in that courtroom that is against those other 4 co-defendants, that cannot be used against you, and that's use immunity. So your testimony in that courtroom in someone else's trial can't be used at all. But it doesn't prohibit us from using that earlier statement or independent evidence to still hold them accountable for their participation in this crime.
Very well.
So this will be a very excellent tool and really necessary for combating gang violence that we've seen certainly in this community and others in Oregon.
Well, we've got 2 more to go, and we have 4 minutes left, so we'll give about 2 minutes to each of them.
Okay.
But that's okay. We've covered some important points here. Measure 74 is another provision that's in front of us, and I'm reading this, and it reminds me that we're talking about the imprisonment imposed by a judge in open court.
Yes.
And the situation there is that this says that the legislature cannot retroactively go back and reduce sentences for people already sentenced unless the judge agrees. It doesn't reduce or affect the governor's power to grant clemency or pardons. Can you tell us a little more about the measure and why it's important?
Well, I think it's important because we've said that victims have a right to speak at sentencing. So a judge hears that and can take that into account at sentencing. This right just simply says, if you're going to change a sentence, it's got to go back to the judge, so it will be done in open court, where again a victim has a right to speak. You aren't going to change it by a legislative vote or by a parole board vote or by a bureaucratic rule where it's hidden, where a victim doesn't have participation, but you just have to do it back in open court where a victim has a right to speak. That's all it says.
All right, we've got one more here, which is ballot measure 75, and this has to do with the composition of the jury. And it says constitutionally that felons cannot serve on a jury for 15 years after they've served time or they've been incarcerated, and that persons who've been convicted of misdemeanors involving violence or dishonesty cannot serve on a jury within 15 years after that conviction. And this is grand juries and criminal juries, that they're prevented from serving on those kinds of juries. What's the importance of this provision?
Well, I think, again, crime victims have looked at that and said, we don't want to have people who have major felony convictions, who have proven to be dishonest, that has resulted in convictions in the past, making these decisions about whether or not someone should be held accountable for their crimes. And they believe to really have a fair jury panel, those prior convictions and people who have those convictions should wait a period of time before they serve on a jury.
One of my favorite lines is, we prohibit felons and persons convicted of misdemeanors involving violence from possessing firearms. So we're not willing to trust them with a gun, which is fine, okay. Why would we be willing to trust them with sitting on a jury where they get to make decisions about whether or not someone gets convicted of a crime and may or may not go free based on that person's participation in the process? Something else about this, I heard some media folks making light of the misdemeanors involving dishonesty or violence, saying, well, if you go out there and you don't have the proper permit for hunting or something, that you might be convicted. Actually, the dishonesty concept is much narrower than that. Does it have to do with your truthfulness or untruthfulness generally?
Yes, exactly. And we've had that concept in the law before. The courts adopted balancing tests, and always in the past it related straight to honesty and deception. That had to be part of the crime.
Well, the critics would make one think that we're just going to go all to pieces if we pass these measures. What is your perspective about these measures overall? We've got about a minute left. Any parting shots about them generally?
Well, all of these measures that we've mentioned in each one of them, they really are the state of the law in most other jurisdictions in the United States. And it doesn't detract any constitutional rights whatsoever from a defendant. It simply puts a victim at a higher level and gives them some rights. But I think the major overall view is this is the way courts operate in most other jurisdictions. And victims see that and they say, gee, if my crime would have happened in this other place or across the river, these rules would have been in place and maybe this person would have been held accountable. That's really some of the motivation for the measures.
This is our chance to make decisions about these victims' rights measures in this November 2 election. So please watch for those mail ballots and make a point of voting and vote on 68 through 76. And I would hope that you would vote yes on the victims' rights measures 69 through 75. Thank you for joining us.